Hello there, kids. Today's online lesson is going to deal with the Supreme Court case Morse versus Frederick. This took place in 2007. So, what is this all about? Well, on January 23rd, 2002, students and staff at Juneau Douglas High School in Alaska were permitted to leave class. They were going to watch the Olympic torch pass by. This was when the Olympics were going to be in Alaska. Joseph Frederick, who was late for school that day, joined some friends on the sidewalk across from the high school, off school grounds. Frederick and his friends waited for the television cameras so they could unfurl a banner reading, "Bong Hits for Jesus." Yes, you heard that correctly. Bong Hits for Jesus. Frederick was quoted as saying that he'd first seen the phrase on a snowboard sticker. Understandably, when they displayed the banner, then Principal Deborah Morse ran across the street and took it away from him. Morse initially suspended Joseph Frederick for 5 days for violating the school's anti-drug policy, but later increased the suspension to 10 days after Frederick quoted Thomas Jefferson. He probably was being a smart aleck, but let's be honest, I still would have liked to have been there to hear what he said. Frederick appealed his suspension to the superintendent. The superintendent denied his appeal, but limited the suspension to 8 days. Frederick then appealed to the Juneau School Board, and they upheld the suspension on March 19, 2002, saying it was a legitimate suspension. Frederick wasn't done. On April 25, 2002, Frederick filed a civil rights lawsuit against Morse and the school board, claiming they violated his federal and state constitutional rights to free speech. What exactly did he want? He wanted it known that his First Amendment rights were violated, and any reference to the suspension was to be taken off of his permanent record. He also wanted money for the attorney's fees, as well as punitive damages, which is basically money in his pocket. The United States District Court for the District of Alaska dismissed Frederick's case. They said that, given the facts, Morse and the school board had not infringed upon Frederick's First Amendment rights, because Principal Morse had reasonably interpreted the banner as contravening the school's policies on drug abuse prevention. Frederick appealed again to the Circuit Court. The Ninth Circuit Court reversed the decision of the District Court. The decision was unanimous, and the decision was written by Judge Andrew Kleinfeld. First, the court decided that the incident should be interpreted under school speech doctrines, even though Frederick was standing across the street and not on school grounds. For Judge Kleinfeld, the question came down to whether our school may, in the absence of concern about disruption of educational activities, punish and censor non-disruptive, off-campus speech by students during school-authorized activities because the speech promotes a social message contrary to the one favored by the school. Basically, he is saying that the school cannot take away your freedom of speech just because you are saying something that the school does not like. Now, as you can imagine, there was a great deal of public response. Could you imagine this happening in Westfield, Indiana? The school district superintendent, a lady named Peggy Cowan, stated, "My concern is that the court's ruling could compromise our ability to send a consistent message against the use of illegal drugs." Now it was time for the school district to appeal. They appealed all the way to the Supreme Court. Now you have to imagine, the court receives upwards of 10,000 appeals every year, of which they will listen to 75 or 80. So the fact that the Supreme Court decided to hear this case is really impressive in and of itself. Now, I'm not going to turn this into a government class, but you have to understand the way the Supreme Court works. There are 9 justices. They do not have a jury. Basically, what happens is lawyers for either side come in, make their arguments. The judges are allowed to ask questions, and then they render a decision. The school district got to make their argument first. Kenneth Starr was their lawyer, and his first statement was based on the fact that you are allowed to have the right of free speech as long as that free speech is not disruptive. He said that the disruptiveness in general terms is behavior that is oppositional to the educational mission of the school, and what he's referencing here is the sign that Joseph Frederick put up. Specifically, in terms, it is a violation of the school's announced policy to enforce and support laws with respect to the control of marijuana. As you can imagine, there were a great many people who were in support of the school district. Deputy Solicitor General Edwin Needler spoke on behalf of the school district, saying, "The First Amendment does not require public school officials to stand aside and permit students who are entrusted to their supervision and care to promote or encourage the illegal use of drugs." Then Joseph Frederick's lawyer was allowed to speak. His lawyer was named Douglas K. Mertz. He said, "This is a case about free speech. It is not about drugs." Chief Justice John Roberts responded, "It is a case about money. Your client wants money from the school principal personally for her actions on this case." Perhaps Roberts was allowing us to see how he felt about the case a little bit early. Mertz emphasized that the torch relay was not school-sponsored, that he had not stepped on school property at all before unfurling the banner, and that the unfurling of the banner did not cause any disruption. Based on these facts, he concludes, his case does not present the issue of school authority over student expressions on campus or any school-sponsored activity. After hearing both sides of the argument, the Supreme Court justices decided on the case. In a vote of 5-4, they voted that Joseph Frederick's First Amendment rights were not violated. Chief Justice Roberts wrote a brief that expressed the opinions of his own and the other 4 justices on his side. He said that the school officials did not violate the First Amendment. To do so, he made 3 legal determinations. First, that school speech doctrine should apply because Frederick's speech occurred at a school event. Secondly, that the speech was reasonably viewed as promoting illegal drug use. And third, that a principal may legally restrict that speech based on the 3 existing First Amendment school speech precedents, other constitutional jurisprudence relating to schools, and a school's important, indeed perhaps compelling interest in deterring drug use by students. Now let's take a little bit of a closer look at that statement. Now, what is this school speech doctrine that Roberts is talking about? Basically, school speech doctrine is an interpretation of your First Amendment rights to free speech as it applies to a student. Essentially, your rights to free speech as a student are different than those of everyone else. When Roberts spoke a little bit more about whether or not it was a school-sanctioned event, he said, "Under these circumstances, we agree with the superintendent that Frederick cannot stand in the midst of his fellow students during school hours at a school-sanctioned activity and claim he is not at school." With regards to whether or not Frederick was promoting drug use, Roberts determined that the principal's conclusion that Frederick's banner advocated the use of illegal drugs was reasonable. He acknowledged that the banner's message was cryptic. Nevertheless, it was undeniably a reference to illegal drugs. To sum up, Roberts said that student expression may be suppressed only if school officials reasonably conclude that it will substantially disrupt the work and discipline of the school. Now, as I said, the vote was 5-4. So if 5 justices believed his First Amendment rights were not violated, it means that 4 justices believed that they were. Justice John Paul Stevens wrote a brief for those 4 that argued that the court did serious violence to the First Amendment in upholding the school's decision to punish Frederick for expressing a view with which it disagreed. Stevens wrote, "The school's interest in protecting its students from exposure to speech reasonably regarded as promoting illegal drug use, cannot justify disciplining Frederick for his attempt to make an ambiguous statement to a television audience simply because it contained an oblique reference to drugs. The First Amendment demands more. Indeed, it demands much more." Stevens also said, "Encouraging drug use might well increase the likelihood that a listener will try an illegal drug, but that hardly justifies censorship. Carving out pro-drug speech for uniquely harsh treatment finds no support in our case law and is oppositional to the values protected by the First Amendment. Stevens also took issue with the majority's interpretation of the banner as being a serious incitement to drug use. He said, "Admittedly, some high school students, including those who use drugs, are dumb. Most students, however, do not shed their brains at the schoolhouse gate, and most students know dumb advocacy when they see it. The notion that the message on this banner would actually persuade either the average student or even the dumbest one to change his or her behavior is most implausible." So, essentially, the Supreme Court said that a school district can restrict your rights to free speech if they reasonably believe that is going to disrupt school activities. Well, how did it end for Joseph Frederick? Well, the U.S. Supreme Court decision did not resolve all the issues in the case. Frederick claimed his speech rights and the Constitution of Alaska were violated, and the issue was argued in front of the Alaska Court of Appeals in September 2008. However, the school district agreed to settle out of court before the judges reached a decision. In November 2008, the district paid Frederick $45,000 to settle all remaining claims and agreed to hire a neutral constitutional law expert to lead a forum on student speech at Juneau Douglas High School by the end of the school year.